Welcome everybody to the University of Maine School of Law. My name is Peter Pittigoff. I'm Dean of the Law School, and I'm especially pleased that my colleague Mel Zarr will speak this afternoon about his work in civil rights in the 1960s and about related challenges today. Just yesterday, you may have read the United States Supreme Court upheld a voter-approved amendment to Michigan's Constitution banning race-conscious admissions in public colleges in Michigan. Civil rights issues 50 years ago are still pressing and urgent today. And as you know, this year marks the 50th anniversary of the enactment of the Civil Rights Act of 1964. The University of Maine School of Law is honored to collaborate with the NAACP of Portland and a number of other co-sponsors in a year-long series of events in Maine to reflect on the civil rights movement through the last 5 decades and today. So many thanks to the NAACP and to Rachel Talbot Ross and to so many contributors to this series. Thanks too to my law school colleagues, Kayla Ramsey and Kerry Weiler and Professor Christine Davik for their work in organizing today's event, and to Angela Cook, who is filming and recording. Let me just note in advance that when we get to the questions and answers, if you could ask your questions into this mic, which we will pass around, please do so for the recording. And thanks, of course, to Professor Mel Zarr, Professor of Law on the Maine Law faculty since 1973, and teacher for many of the lawyers and leaders of Maine today. Professor Zarr is an active member of the Maine Criminal Law Advisory Commission, which advises the legislature on criminal law matters. He also serves as a consultant to the Maine Judiciary's Advisory Committee on the Rules of Criminal Procedure, and he's an elected member of the American Law Institute. In addition to teaching at Maine Law, he served for 5 years as U.S. Magistrate for the Federal District Court in Maine and as Special Assistant to the Attorney General. Prior to his academic career, Professor Zarr was co-director of the Massachusetts Law Reform Institute, where he focused on issues of poverty law. And particularly notable for today, he was a staff attorney at the NAACP Legal Defense and Education Fund from 1963 to 1970. That experience at the Inc. Fund, as we call it, put him in a central and important position in civil rights work in the 1960s, from New York City to Mississippi, Georgia, Louisiana, and he carries that experience and those deep values to his work today. So please join me in welcoming Professor Mel Zarr.
Thank you, Peter, for that introduction, and I also want to thank the organizers for giving me this opportunity to reflect on my experiences in the 1960s and whether those experiences have anything to do with what we're facing today. And I've enjoyed that reflection, and I've come to the conclusion that they do. And so I have to give some background to all this, and then I will bring it up to the present date. We're 50 years on from the Civil Rights Act of '64, but I want to turn your attention first to a year before that, in 1963, where some notable events occurred. In the spring of 1963, Dr. King went to Birmingham and led protest demonstrations there, and that led to the fire hoses being turned on the protesters. You probably have seen the pictures of that. And he wrote his famous letter from the Birmingham jail during that episode. On August 28, 1963, he gave an I Have a Dream speech at the Lincoln Memorial as part of the March on Washington for Jobs and Freedom. That's what it was called, the March on Washington for Jobs and Freedom. There's a footnote, also in 1963, I, as a newly minted lawyer, joined the staff of the NAACP Legal Defense Fund. That's my personal footnote. The full name of the organization was the NAACP Legal Defense and Educational Fund Incorporated, or INC. And so people in the movement decided to call it the Inc. Fund. And that's what Peter referred to it. If you were an insider, you knew what the Inc. Fund referred to, and if you didn't, if you weren't, well, too bad. The Inc. Fund had been headed until 1961 by Thurgood Marshall. And he left then to go serve on the Second Circuit, and then was Solicitor General, and thereafter in 1967 on the U.S. Supreme Court. I was hired by his successor in 1963, but I did get to know Thurgood a little because he would come from time to time back to the Inc. Fund headquarters, and he would sit in the library and tell stories to anyone who wanted to come by and listen. And it's always a source of some regret that I was often so busy with my pressing work that I didn't get to hear as many stories as I should have heard. But he was kind enough to move my admission orally to the Supreme Court bar while he was Solicitor General. The Legal Defense Fund was general counsel to the Southern Christian Leadership Conference, SCLC, headed by Dr. King. And so I dealt with Dr. King, and I dealt with his principal deputy, Andy Young, who was perhaps more understanding, as I'll explain, in dealing with legal matters, and other people on the staff. So as general counsel to SCLC, when SCLC had a series of demonstrations, and Dr. King was there, depending on where it was, so was I. Now, the Civil Rights Act of 64 had certain notable features. Title II dealt with public accommodations, that is, things like parks and pools and lunch counters and you name it. Am I making this noise? During the law, Howard, there's a seat right here in the front row. You don't need to stand.
Like I'm back in law school.
And Ed, there's some seats in here. Hate to see someone standing unnecessarily.
Gee, talk about prime seating.
That's right. You timed your entrance during a lull, shall we say. Can I proceed?
Yeah, you should be sad.
Right. Okay, good. Terrific. Excellent. Okay, I was talking about the Civil Rights Act of '64 having certain notable features. Title II dealt with public accommodations, and I still remember very keenly coming to Mississippi in the spring of '64 and being startled by seeing all these white and colored signs. I was raised in Massachusetts, went to college and law school in Massachusetts, never been to Mississippi, and it was a real shock, a real slap to come and see everything had white and colored. You name it, it was white and colored. And that was dealt with by Title II of the Civil Rights Act of '64. Title VII of the Civil Rights Act, which was also very notable, dealt with employment discrimination, prohibiting discrimination on the basis of race, and then by amendment on the basis of gender in employment. But what is perhaps often not remembered is that there were voting rights provisions in the '64 Act, which were stripped out as a matter of compromise, and so the '64 Act had nothing of substance about voting rights, which figures prominently in the story. the events that would affect voting rights then took place not in Washington, at least not initially, but in other places far from Washington. In Mississippi in 1964 and in Selma, Alabama in 1965. First, let me talk about Mississippi Freedom Summer. That's when I first got involved in Mississippi directly. Actually, let me just say that my remarks will be divided into three parts. One deals with the events of 64 and 65. The second part will deal with the events of 1968, and the third part will bring this all down to date, and I'll tell you what I've learned as a part of my reflections on what this all has to do with the present. I need to give you some background to what happened in Mississippi and Mississippi Freedom Summer in 1964. The principal activity was going to be and was voter registration. So what was the problem? After all, the 15th Amendment to the United States Constitution had provided, ratified in 1870, for voting without regard to race. Well, there were two kinds of problems. The first kind of problem was the culture of fear in Mississippi. There was a reluctance to register, and it was a reality-based fear. There was a fear of violence. The KKK was very much active, and if you were uppity enough to want to try to register to vote, that could often lead you to dire consequences, perhaps even loss of life. There was also the threat of loss of housing, of jobs, other threats as well. Many people who worked in the fields on plantations would find if they tried to register to vote, the plantation owner would throw them out of their houses and they would lose their jobs. And so there was a reality-based fear of voting. And then the second kind of problem was if you plucked up your courage and went to the registrar's office and tried to register to vote, there were two kinds of problems. One I will call the long wait problem. The long wait problem is caused by when the registrar would see you coming to the town hall, they would go to lunch. Or if it was before lunch, they would have their morning break. Or if it was after lunch, they would take their mid-afternoon break. And so you would have to wait until they came back. And sometimes they would, and sometimes they wouldn't. And so you had to have tremendous patience if you had plucked up your courage enough to go to vote. The second obstacle was, assuming you in fact waited long enough, the second obstacle was the literacy test. If you were white, you would get to read and explain a provision of the Constitution that said how old you had to be to run for office. That was not hard to read and explain. If you were African American, you would have to explain a dense provision of the Constitution dealing with mill rate taxation of localities, which a lawyer would have difficulty reading and explaining. So virtually nobody passed the test. The objective of Mississippi Freedom Summer was to, in fact, educate and organize. There were going to be civil rights workers who would, in fact, go door to door and try to convince people to go to register to vote. There would be meetings held to, in fact, try to get people to register. People would go to the schools and talk to the kids, and the kids would go home and talk to the parents. Those are all techniques. And another technique was the march, the Civil Rights March. That had a two-pronged objective. One was to combat this culture of fear, and the second was to protest the official obstacles to voting. Now, these marches often led to arrests for basically nickel and dime stuff, disorderly conduct, parading without a permit, obstructing public ways, etc. But in fact, once you landed in jail, the bail might be set real high, and that was meant to be a deterrent to, in fact, doing any more of these marches. Well, here's where the Ink Fund lawyers came in, and what we had to do was to figure out what to do about all these folks who were in jail as a result of the marching. We did not want to try these cases in state court, and we wanted to try to get them into federal court. But how could we do that? It was not easy. and we were figuring out theories when we got a call in May of 1964 to come to Mississippi. This was even before Mississippi Freedom Summer, because some of the folks had landed in jail because of protests. The call came to me. It was from someone named Mickey Schwerner, and he was in Meridian, and he was leading a voting rights campaign, and he had gotten some folks in jail. And he wanted a civil rights expert to come to Mississippi and help out. I was the designated expert by my boss. I had all of 8 months of legal training, and I was deemed an expert. Well, of course, there weren't too many experts in that anyways, and so if you were 8 months in, at least you had some claim. I never saw Mickey Schwerner personally. I talked to him on the phone. I never met him. A volunteer law professor and I went to Mississippi, and we tried to remove the cases to federal court. There was no precedent for doing this. I mean, you've seen removal in your travels, but that's removal of civil cases. Removing criminal cases to a federal court was something unheard of. And the statutes didn't exactly say that, except there was a Civil Rights Act dating back to 1866 that could be read as saying that you could, under certain circumstances, undefined, remove certain criminal cases involving civil rights to federal court. And so we tried it. And we removed the cases to federal court, and we kept removing cases to federal court. As fast as they could arrest them, we could try to remove them to federal court. As I say, there was no precedent for it, but it had the marvelous effect of stopping these prosecutions in their tracks. And until the Supreme Court put us out of business in 1966 with a 5-4 decision saying that we couldn't do it, we made removal work very well for us. And then what happened was these cases disappeared. I never knew what became of them. All over Mississippi, these cases just went away. I didn't want to ask too intently about this. I just figured that was great. By the time the removal had done as much as it needed to do at the time, like a first stage rocket, it just fell away, and after that we were okay. So that is in May of 64 and thereafter, but I want to also draw attention to June of 64. There was an orientation meeting in June at a small college in Ohio of northern college students, mostly white, who were going to go and work in Mississippi, part of Mississippi Freedom Summer. I went to talk about Mississippi criminal law and Mississippi criminal procedure, of which I was fast becoming an expert. My substantive criminal law experience was mostly with stuff like disorderly conduct, etc. That seemed to me our expertise. But criminal procedure was a real expertise of mine, because the prosecutors and the courts were only too happy to engage in a procedural default analysis if we did anything like fail to cross a T or dot an I. And so those of you who have taken procedure with me know that I take procedure very seriously. Because of my background, I understood that we had to have papers that were absolutely clear and bulletproof. And so as a result, I was, I think at one point, as big an expert in Mississippi criminal procedure as any practitioner in the state. I knew the code procedure back and forward. So I went and talked about that to these Northern College kids who were about to go to Mississippi and insist in voter registration. Their role would be to try to overcome the culture of fear and to organize voting registration activity and help as best they could in educating and organizing with respect to the right to vote. But there was a deeper mission that went unsaid. And that deeper mission was that they were, in fact, engaging in a very dangerous experiment as to what might happen once they came to Mississippi. And, in fact, it did. A fellow named Andrew Goodman, who I never met in Ohio, was joined up with Mickey Schwerner and a local worker named James Chaney, and they went to investigate a report of a church bombing in Philadelphia, Mississippi, and they never came back. The experiment actually had very important national implications. In a sense, you could say the experiment worked. The FBI was tasked by President Johnson to investigate. They were very reluctant to do that, but they did. Public opinion was outraged, and in fact, the judiciary was mobilized, the federal judiciary, and there was legislation passed, not coincidentally, but it was already in the works. The Civil Rights Act of '64 passed in July of 1964, some weeks after the disappearance of the three. So the rest of the summer of '64, I spent in Jackson, and basically we were, as I say, trying to get these cases out of state court and into federal court. We used removal, as I said, and we also used federal injunctions. But here we had a problem. The local federal judge was someone who has historical significance named William Harold Cox. None of you have ever heard of William Harold Cox, I'm sure. But he was part of a deal that President Kennedy did with James Eastland. James Eastland was holding up Thurgood Marshall's appointment to the Second Circuit in 1961. James Eastland was the long-time notorious chair of the Senate Judiciary Committee. And he was holding up not only Thurgood nomination, but he was holding up other of Kennedy's nominations. And so they did a deal. Eastland said, I want you to put my college roommate, William Harold Cox, on the federal court in Jackson in exchange for releasing all these other folks, including Thurgood, to the federal court. And so Kennedy did the deal, and William Harold Cox went on the bench, and he was trouble. And in fact, he would in fact use, in my presence even, the N-word. He had no compunction about doing that. And of course, he never gave us any relief. He always complained that we were just using him as a way station on the way to New Orleans, the Fifth Circuit. And I told him, there's a way you can prevent that. But he didn't take the hit. And that led to some, the law's delays, including William Harold Cox, led to a number of conversations with Dr. King that were not of the best. I wish I could report that when I talked to Dr. King about these legal developments, he said, "Attaboy, Professor Zarr," not Professor, Brother Zarr, he always said, "Brother Zarr, you're doing a great job." No, didn't happen. Usually the tenor of the conversation was, "Brother Zarr, you mean to tell me blah, 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 blah." And I would, in fact, have to tell him, yes, that's true. We're going to have to go through Judge Cox, and it's going to take a while, and then we'll finally make an appeal to the Fifth Circuit, and finally we will get something going on here. And he was not a patient man, let me put it that way. But he was respectful of the law, and that was I think looking back, I always had a better time talking to Andy Young, who was more understanding than Dr. King. But as I say, those are the nature of our conversations, except for one. We had one exceptional conversation later, which I'll tell you about, but that comes later. We did have a big success in the summer of '64, which was to, in fact, speed things up a lot. When Judge Cox turned down our request for an injunction, we went to the Fifth Circuit and got something called an injunction pending appeal, which you don't hear about very much. It's scarce as hen's teeth. But we got it from the Fifth Circuit because I think they understood what Judge Cox was up to, and they gave us relief. So as a legal victory, it was very satisfying, and I'm sure Dr. King was pleased, although I think I talked to Andy about that one. In the spring of '65, Dr. King took his voting rights campaign to Selma, Alabama, and I'm sure that you've seen the pictures of the Bloody Sunday, the horses trampling the demonstrators on the Edmund Pettus Bridge. I don't know if you've seen them, but the legal defense firm went to federal court before Judge Johnson to get an injunction to allow a march from Selma to Montgomery. And there, I was not in Alabama. My role was backup. And you have to imagine what a role of elite backup was in those days. Back in those days, before computer research, what you did was you went to the books. And in Selma, the lawyers on the front lines in Selma did not have the books. I was back in the library with the books. And so I did a lot of the research, and we had the phone lines open for hours at a time. I would find stuff and read stuff and write out stuff and dictate it to their secretaries and stuff. And that's the way legal research at a distance worked then. And we won a great victory. Judge Frank Johnson, I don't know if any of you ever heard of him, issued an injunction in a case called Williams v. Wallace. It's actually worth reading. If you go back, it's in the Alabama District Court in 1965, the District of Alabama in 1965. It was a great victory. And so what that did, the events in Selma, led to the passage of the Voting Rights Act of 1965, which in fact I think is the most consequential act that we've had. The Civil Rights Act of '64 was important, but I think the Voting Rights Act was even more important. What we had in Selma was the perfect alignment for a movement. You had a narrowly defined goal, which was voting rights. You had an identifiable target. Sheriff Jim Clark, just like in Birmingham, there had been Bull Connor. You had Sheriff Jim Clark. You had the horses and the brutality. And in fact, it captured the conscience of the nation. The president was on board. The people were outraged. Congress was willing to do something. And that all led to the passage of the Voting Rights Act of 1965. The period between '64 and '65 was a period of great success, of great legal success in Congress and in the courts, in the federal courts. Contrast that with 1968. The 1963 march had been on Washington, and it had been for jobs and freedom. The freedom part was making good progress in this Voting Rights Act of '65 and the Civil Rights Act of '64. The jobs part was not. The economic justice part was not. And when you think about it and compare it to the Selma campaign, you can see what the differences were. In Selma, you had identifiable targets and very clearly defined goals. Here, when you're talking about economic justice, about jobs, it's hard to see who are the exact targets, what exactly is the goal, how to mobilize public opinion. Protesting the presence of oppression is quite a different thing from protesting the absence of opportunity. And so it was much tougher going for Dr. King. He tried in 1966 in Chicago. Little was accomplished. David Carricker is here, and he was in Chicago in '66. By 1968, the Dr. King's organization, SCLC, was working up a new march on Washington. This would be the Poor People's March for Economic Justice. It's called the Poor People's March. But even then, in the run-up to that, it was not clear that this was going to be a success. It was hard to mobilize public opinion. The tools didn't seem to be there. contemporaneously, Dr. King's nonviolence approach had been sorely tested in Memphis, where he'd gone to support the sanitation workers, and there his nonviolent march had been infiltrated by gangbangers who used the march as a cover for looting. And that had led to a lot of condemnation of Dr. King, and he was really feeling the heat. In addition, there was a lot of self-imposed heat on Dr. King because he had come out against the Vietnam War. And he had done that for a couple of reasons. One, it was diverting attention and resources from the domestic agenda. And two, he couldn't help but notice that without economic opportunity, black males were going into the military in disproportionate numbers and fighting and dying in Vietnam. And so he took an anti-Vietnam stance. But this, in fact, put him at some risk and some cost. His opposition to the Vietnam War cost him support in Congress. President Johnson turned his back on him. There was no judicial hook for this. It isolated him from other civil rights leaders who were only too glad to stiff-arm him and compare and contrast themselves from him. And in fact, it reduced SCLC contributions so that his organization was hurting. In fact, he left no will and had $600 in assets. Three weeks before his assassination, in mid-March, SCLC had called an organizational meeting in Atlanta to figure out how this was going to go down. It was at our favorite civil rights hangout, which was the back room of Pascal's restaurant in the west side of Atlanta. We had our big meetings there in the back room of Pascal's. One bomb could have eliminated the whole civil rights movement. I don't remember exactly, but it was somewhere in mid-March. It was about 3 weeks before his assassination. I'd been working in Mississippi, working on the Mississippi part of the Poor People's March. It was going to start with a mule train in Marks, Mississippi, in the Delta, and then move throughout the South and end up in Washington. I got to Pascal's late. I was tired, and I could hear that the meeting was going on in the back room. It started already, and I had a choice to make. I could go into the meeting, or I could first have supper. And those who know me know what choice I made. So I sat down in the front of Pascal's and was having supper, and I had assumed Dr. King was in the back with the rest of them, but he wasn't. He'd come late too. He came in late and he sat down and we had a talk, and this was a talk of a quite different tenor than we had had before. He talked about how he was, in fact, he and the organization were really sustaining enormous costs. That his opposition to the Vietnam War had lost him political support. He was having great difficulty rallying any contributions. He had to keep fighting off these other civil rights leaders. He was losing support in the black community, many of whom thought that he was not supporting the troops. And so he was under great strain, under great pressure. And yet he wouldn't waver. He said he had to do this. He had to have the courage of his convictions. I think back to that. Because Dr. King today is kind of like a plastic figure. I mean, he's on the stamp, on the statue, there's a holiday and whatnot, and it's hard to remember. You have to remember what he was going through. He had a tumultuous, turbulent, contentious, and messy life. And in my conversation with him, all those things were coming to the fore. But he kept maintaining, you just have to have the courage of your convictions. So we finished supper and went into the meeting. After Dr. King's assassination, the Poor People's March went forward. I was in Mississippi, in Marks, Mississippi, at the start of the march, and I had, truth to tell, virtually nothing to do. Everywhere the march went, the towns would pass on through. They might litter, no charges. They might trespass, no charges. They might be a little disorderly, no charges. The towns had realized that the only way to get rid of these people was to ignore them. And so they passed through Mississippi without incident. As I say, I had virtually nothing to do. There were no arrests, nothing to remove. I couldn't remove it anyways, but nothing to try to enjoin. They just kept going, and eventually ended up in Washington, where predictably the whole thing failed. With diffuse goals and no target, an unsympathetic president, Congress that wouldn't get involved. The whole thing became kind of an embarrassment, and that pitch for economic justice, in fact, failed. And with it, my time on the demonstration team, my time working on demonstrations came to an end. I didn't leave until early 1970, but I worked on appellate briefs, had an oral argument in the Supreme Court, did school desegregation work, did other kinds of civil rights work, but no more demonstrations, no more injunctions, et cetera, et cetera. So that concludes parts 1 and 2 of what I have to say. But I want to try to bring this down to, in part 3, to the present day, because I think that there are some parallels that I want to draw. And I want to focus on voting rights and economic justice. First, with respect to voting rights, the Voting Rights Act of '65 did, in fact, overcome the culture of fear, overcame a great many of these obstacles. But 2014 presents new problems with respect to voting. We don't have, as I say, the culture of fear, but there are some things that remind me of 1964. There are two kinds of obstacles in particular. One is the long wait problem is back. Instead of the registrars who take long breaks, what you basically have are pieces of legislation that are disgraceful. They, in fact, are eliminating same-day registration. The location of polling stations is made inconvenient. The number of voting machines is selectively allocated. Fewer polls are open in the wrong districts. Basically, there are all these restrictions on absentee voting. No more Sunday voting, where carloads of black voters used to go. All of this is to create bottlenecks at the polls where, in fact, the wrong kind of people are trying to vote. In Ohio, for example, if you were, in fact, in a rural area or in a white area, you just walk right in and vote. In minority areas, the lines are long, sometimes as long as 8 hours, and it is disgraceful, and it is open. There's not much doubt of what these legislatures are trying to do in terms of voter suppression. In fact, we even have a name for it, called voter suppression. And then the other kind of obstacle is that even if you wait and wait and wait, when you get to the poll, instead of a literacy test, those are gone, you now have something called voter ID. And you're meant to give a passport or a driver's license or something, knowing full well that many in minority communities don't have that. And they could maybe get some substitute, but it will be hard. It'll slow them down. And so what you have here is a situation that reminds me a lot of 1964 in Mississippi. In terms of a remedy, the president is deploring it. I noticed just 11 days ago that he made a speech in which he talked about these voter suppression efforts, but he is virtually powerless. He can deplore, but he doesn't have any power because Congress won't do anything for him on this subject, as on any other subject. And so he is, in fact, powerless to help with this. The U.S. Supreme Court and the federal courts, well, they seem to have another agenda in mind. Last year, in a 5-justice block, the Supreme Court voted to invalidate the key provision of the Voting Rights Act of '65. How could they do that, you could ask? Well, they found in the 14th Amendment a right of states not to be discriminated against in the coverage of the Civil Rights Act of '65. That's 5 justices who did that in the Shelby County case. They didn't need to go that far in Shelby County, but they reached out, like the activists they are, to, in fact, invalidate that. And so I don't have much hope on that score. The economic justice part of Dr. King's agenda also is reminiscent of what he worked on. The disparity between the rich and the poor is greater now than at any time since the Gilded Age of a century ago. And the problems of the poor are obvious, and the inability of Congress to do anything about it is obvious too, or the unwillingness to do anything about it. Which leads to a question in my mind, which I've been ruminating about ever since I had the opportunity to give this talk, which is this: in a democracy, how is it possible to get the majority of the voters to vote against their economic interests? And my conclusion is, it's possible. It's not easy, but it's doable. But it just takes an awful lot of money. You can do it with money. First, you support politicians who want to keep the wrong kind of people from voting, and I've talked about that already, the voter suppression efforts. And secondly, if you can't keep them from voting, at least you can distract and deceive them. And with enough money to flood the airways, you can, in fact, distract them as to any number of side issues, usually involving character assassination, and deceive them as to what is going on. My favorite bit of deception is to condemn the poor, not the rich, for engaging in class warfare. This is the charge of class warfare is particularly ironic. But if you have the money to flood the airways to do that, you can make it work. And the Supreme Court here again, at least a 5-block, the same 5-justice block who crippled the Civil Rights Act of '65 are now finding in the First Amendment a new right of the wealthy to control elections. And we all have heard of Citizens United in 2010. Just 3 weeks ago, in the McCutcheon case, Chief Justice Roberts for the 5-justice block wrote, this is the first sentence of his opinion: "There is no right in our democracy more basic than the right to participate in electing our political leaders." He then went on to hold that the right to participate that he was talking about was a right that the 5 justices had found in the First Amendment to allow the wealthy to essentially buy elections. It really amounts to that because they invalidated aggregate limits on contributors, because now they can give as much in aggregate way as they can as they choose. And so it's that same 5-block vote. Now you would think that someone would come along and say, well, this is a very pregnant sentence, this first sentence of the opinion. There is no right in our democracy more basic than the right to participate in electing our political leaders. That could be used in any attack on these voter suppression tactics. My guess is that the same 5 justices who penned that would say, well, no, this is a matter of states' rights when talking about voter suppression. We're dealing with voter fraud. And so I don't hold out much hope for that Supreme Court as long as it's dominated by that 5-block majority. So I don't want to end on a down note. I want to say that there is a remedy. And I want to suggest that the remedy is the same remedy that Dr. King and those brave souls in Mississippi Freedom Summer, '64, have given us something to think about. Education and organization. It's not easy. It wasn't easy then, it's not easy now. But you have to educate people as to what's going on, to explain what's going on. You have to organize, try to use the legal tools at your disposal. But Dr. King said you had to have the courage of your convictions. But they had it a lot harder. If they had to wait a long time, they waited. If they had to overcome official obstacles, they did. They used the legal tools available, and they didn't lose hope. That's the message for today. Well, we have a few minutes for some questions. Who wants to ask a question?
Professor Zarr,
Yes.
how would you compare, I'm sorry, how would you compare Citizens United and McCutcheon to the old poll tax?
To what?
The old poll tax.
Right offhand, I'm not sure I do see much of a comparison. I compare the old poll tax to the old literacy test. They're just another obstacle. But the poll tax was invalidated and the literacy test was thrown out. And so I think those kind of obstacles have gone. But I think that the new obstacles are more pernicious.
I just saw Justice Sotomayor quoted yesterday as saying that the majority in this just decided case had no feeling for what it was like to be discriminated against racially. Do you have any response to that?
I think that Roberts and Sotomayor had a spirited debate. Roberts answered her directly, and she answered him. And basically, what you have, though, is, I think, something that's kind of a sideshow to what I've been talking about. The idea that affirmative action is going to play a big role in this country has pretty much been diminished. I mean, it's not surprising. The decision yesterday would not have been surprising in the 60s and was not surprising yesterday. It was basically the majority saying that the idea of affirmative action is so contentious and so divisive that if, in fact, a state has no history of racial discrimination, there's no intentional discrimination in the case, that, in fact, the states should be allowed, through their people and their voting processes, to, in fact, decide whether to keep or abolish affirmative action. That's not remarkable, it seems to me, and I don't think there's going to be a big rush to have more of these constitutional provisions, because they don't have anything to work against. Affirmative action by race has pretty much been going downhill for some time now. But I think there are other substitutes. I think the way is not to have affirmative action by race, but to think about class-based discrimination. And I think that in our admissions work over the years, I was doing admissions work here, we've always looked at a case for someone who, in fact, had been able to come up from nothing, to be self-made as a real plus for admission. And so that may tend to solve part of the problem. I don't think we'll solve all the problem, but it tends to solve part of the problem.
During your time with Inc., what piece of legal maneuvering are you the most proud of that you yourself did?
Well, I think our campaign to thwart all these criminal prosecutions, I think that was great. As I said in my talk, they went away. We had three techniques. We had removal, as I say, for a couple of years when we needed it. We did a lot with injunctions. We had a lot of great victories with injunctions. And we also tried some pretrial habeas corpus. That worked for a while too. And so I would say creative use of the federal courts to, in fact, help civil rights when they most needed it was probably the best thing I did. But I argued the case in the Supreme Court for a poor black person who had been railroaded and won that. I argued some big desegregation, school desegregation cases, and I was proud of that. But I think getting people off the hook who didn't didn't deserve to be in the criminal justice process was the thing I'm most proud about. Yeah, Jim.
Mel, did your path and David Gregory's cross at all during this time frame?
No, and it's interesting. David was in the Civil Rights Division of the Justice Department. Basically in the South, he never came south. And so when I was in the South, I would deal with John Doerr, who was the head of the Civil Rights Division. So David and I never crossed paths in the South. But interestingly, during that time, the Civil Rights Division was very keen to keep its distance from us. They stiff-armed us a lot because we were, radical rabble. That's what?
You're radicals.
Yeah, every radical. I never thought of myself that way, but we were characterized as the radicals. And Dr. King was the biggest radical of all. Our client was the #1 radical around. Whoever thought he'd end up on a stamp? No, we didn't have a contact. No. Yeah, Chris.
Professor Zarr, I was wondering if you could comment on, as far as modern day voting rights issues, one of the main things that I'm studying is the disenfranchisement of felons and how that disproportionately affects the minority community and the lower classes in general.
Yeah.
Particularly one example is Florida, where some people said the 2000 election would actually have turned out differently had it not been for the disenfranchisement of
Yeah.
felons.
Yeah. Well, let me start with the good news. The good news is that Maine is in the forefront of allowing people who have criminal records to vote, and Maine is probably the leading edge. In a lot of these states, there's litigation pending. I mean, so there is a legal hook. You can grab hold and challenge these state by state, and I think that they're doing a good job. Yeah.
There have been some studies lately about resegregation as desegregation orders have been lifted and the residential demographics are changing. Schools are defaulting back to segregation. Do you see a legal hook for that issue, given that the Supreme Court has taken away so many options?
There's a hook for arguing, but I think the majority of the Supreme Court has pretty much washed its hands of that. I think that they signaled back in 1964 in the Milliken case in Detroit that if people wanted to vote with their feet, they didn't want to go to school with inner city kids, and they wanted to go to the suburbs, nothing federal courts could do about it. And there's been a long, slow decline ever since 1974 on that issue, and so I don't hold out much promise about it. Perhaps more promise in state court under state law. Some of the bigger victories have been won in state court under state law, trying to prevent resegregation. But as far as the federal courts are concerned, I think the Supreme Court has kind of signaled the lower federal courts, we're tired of this. We're done with that. Well, thank you for inviting me, and I'm glad I had a chance to reflect.